Supreme Court strikes down Trump executive order limiting birthright citizenship in a 6-3 ruling. On June 30th, 2026, the United States Supreme Court struck down President Trump's Executive Order 14,160, which had sought to deny automatic citizenship to children born in the United States whose parents were in the country illegally or on temporary visas. In the case Trump versus Barbara, the court ruled 6-3 that such children are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. Chief Justice John Roberts wrote the majority opinion, joined in full by Justices Sotomayor, Kagan, Barrett, and Jackson. The order never took effect, having been blocked by every lower court that reviewed it. A few facts here are undisputed by every side. The ruling came down 6-3. Roberts wrote for the majority, joined by those four justices. Justices Thomas, Alito, and Gorsuch dissented, though not as one voice. Thomas's 91-page dissent was joined only by Gorsuch, while Alito filed his own separate dissent. Trump signed the executive order at the start of his second term in January 2025, and after the ruling he called the decision, quote, "too bad for our country," end quote, and urged Congress to act instead. The ruling reaffirms the framework of an 1898 case, United States versus Wong Kim Ark, which first recognized citizenship for children born in the United States to non-citizen parents. Underneath the legal question sits a harder, structural tension. Beyond immigration policy, this case tested whether a president can redefine a constitutional term by executive order alone. Every lower court and 6 justices said no, setting a limit that will outlast this particular policy. At the same time, restricting birthright citizenship remains a durable priority for Trump's political coalition, so a court loss creates real incentive to escalate toward legislation or a constitutional amendment to keep the issue alive. And there's a concrete human stake underneath the politics. Hundreds of thousands of children are born each year in the United States to non-citizen parents, and employers who rely on visa workers have a stake in a stable rule too. Instability here risks creating a class of children with uncertain status. Each side sees this ruling differently, and it's worth hearing each in its own strongest terms. The Trump administration and congressional Republicans argue that the 14th Amendment's phrase, "subject to the jurisdiction thereof," was written specifically to naturalize freed slaves after the Civil War, not to grant citizenship to children of parents with no lawful permanent tie to the country, and that reading it more broadly rewards illegal entry and what they call birth tourism. Justice Alito's dissent made this case in comparative terms too, calling the majority's rule a, quote, "medieval," end quote, relic that even the United Kingdom abandoned by statute back in 1981, and warning that the ruling preserves a powerful incentive to enter or remain in the country illegally. Because the constitutional reasoning commanded only 5 votes, not 6, some conservatives argue the question remains legally live and could still be revisited by Congress or a future court. Their incentive is to advance a restrictive immigration agenda central to the president's coalition, and their read is that this is a narrow, reversible setback rather than a final defeat. The practical impact: the order is void for now, and the administration is pivoting towards seeking legislation or a constitutional amendment, with Vice President J.D. Vance signaling continued efforts to challenge the outcome. Plaintiffs, civil liberties groups, and Democrats counter that the text of the Citizenship Clause and 128 years of precedent settle the matter. Birth on United States soil confers citizenship regardless of a parent's immigration status, with only narrow exceptions such as children of foreign diplomats. They frame the executive order as an unconstitutional attempt to redefine citizenship by decree rather than by law. Their incentive is to protect birthright citizenship as a firm constitutional guarantee and to establish clearly that a president cannot unilaterally strip citizenship from a class of people. The impact, in their view, is a major legal victory that preserves the status quo for the roughly 250,000 or more children born each year in the United States to non-citizen parents. The American Civil Liberties Union and its co-counsel described the outcome as vindication for their clients. Within the court itself, the majority held that the framers deliberately chose broad, universal citizenship by birth language, and that being, quote, "subject to the jurisdiction," end quote, of the United States simply means being subject to its laws, which nearly everyone present in the country is. Justice Thomas's dissent, joined by Justice Gorsuch, argued instead that the clause requires a parent's permanent domicile or lawful allegiance to the country, so children of parents who are unlawfully or only temporarily present would fall outside it. Justice Alito's separate dissent added that other common law countries have long since moved away from unconditional birthright citizenship. For the majority, this resolved a foundational question of constitutional text and original meaning. For the dissenters, it corrected what they see as a misreading that ignores both the amendment's Reconstruction era purpose and modern international practice. Because Justice Kavanaugh agreed the order was unlawful only on statutory, not constitutional grounds, the ruling leaves a narrow opening that both sides expect to shape future legislative and legal strategy. For immigrant families and foreign nationals on temporary visas, including many Indian nationals on H-1B visas, the ruling means their children born in the United States remain citizens with passports, benefits, and the right to remain, resolving real uncertainty for large diaspora communities. Their incentive is straightforward: securing their children's legal status and avoiding a two-tier citizenship system. Overseas coverage, especially in India, framed the ruling as a stabilizing outcome for migrant families weighing whether to stay in or move to the United States, while noting that India itself abolished unconditional birthright citizenship through amendments passed in 1986 and tightened further by 2003. Across the media spectrum, the coverage split along familiar lines. Center and left-leaning outlets like NPR, The Washington Post, and CNN largely framed the ruling as a rebuke of presidential overreach, with CNN's own headline using the word rebuke even though its reporting acknowledged the outcome was less sweeping than expected. Right-leaning outlets like Fox News and the Daily Wire led with Republican outrage, quoting Vice President Vance's warning that the ruling is, quote, hanging by a thread, end quote, because the constitutional reasoning itself only carried 5 votes. Non-Western coverage, from Al Jazeera to Outlook India, tended to read the ruling through the lens of migration and diaspora self-interest rather than American constitutional history. The detail that reconciles the sharpest disagreement: 6 justices rejected the executive order, but only 5 of them endorsed the constitutional reasoning behind that rejection, which makes both the settled and the hanging by a thread framings partly true. Trump has said he will push Congress to end birthright citizenship through legislation, and House Speaker Mike Johnson said lawmakers are weighing both a new statute and a constitutional amendment. No legislation has passed, and the story is still developing.
Want the whole story, every side with the sources? It's all at pressureoftruth.com.